Amicus Curiae, friend of the court. Hi, everybody. My name is Curtis Walker, and I am going to attempt to get through this week's mini lesson. It's the day after Thanksgiving, so that's a good deal, and I hope everybody had a great Thanksgiving. Forgive me for not looking at the camera, but I had to take care of something right there. Take care of a little something. So I'm going to bring up now what our case or our mini lesson is about. If you will bear with me, I'm going to try to do it. All right, so the mini lesson says discuss the role that amicus briefs play in the judicial process. What is the process for filing an amicus brief? Identify a specific case where the amicus brief and/slash oral argument made a significant difference in the outcome of the case. What points were made or developed that were different or better than the litigants' positions? Of course, we discussed Mapp versus Ohio with Professor Luiso on Monday, so that was pretty cool. And she says, don't use that as an example. All right. That being said, the basic definition of amicus brief is friend of the court, and generally is in response or in relation to a legal brief, generally on the appellate level or at the Supreme Court, which is the highest court of the land level. And I can close that now. I'm going to bring that across. So what I will do is I'm going to attempt, let me take that down and let's say. So the amicus brief and its stages, there is the petition stage briefing. There is the 10-day notice requirement. There is the next steps, like if consent is withheld or if consent is or not given rather. And there's evidence of consent. And then we move on to part 2, which is the due dates, merit stage briefing, and footnote, and as well as other due dates. Okay, so that in a nutshell is that part of it. So again, amicus brief is friend of the court, and as she stated, says discuss the role that amicus briefs play in the judicial process. Okay, so an amicus brief is basically, literally in Latin, amicus curiae is an individual or organization that is not party to a legal case who is then permitted to assist the court and by offering different information or expertise that is not otherwise included in the original brief that has a bearing on the case. So the decisions whether to consider an amicus brief lies specifically within the discretion of the court, and that's an important note that we must make. So the phrase is legal Latin, and the origin of its term goes back to the 1600s, 1605, 1615, and the scope is generally found in cases where, I have to slow down, cases where public interests are involved and concerns regarding civil rights are in question. In American law, amicus curiae generally refers to what other jurisdictions are known as intervenor, or a person or organization to provide some legal submission that is an alternative or an additional perspective, so to speak, regarding the matters that are in dispute. In American courts, the amicus brief is, that's what we call it. And so in other jurisdictions like Canada, amicus curiae is a lawyer, basically, that's asked by the court to provide some legal reasoning that would not otherwise be known, or often, like, both parties is not represented by counsel. I guess we can get into a little bit of the history, which it's direct or indirect connections go back to the Roman judicial experience, and that's, I guess, some debate on that. You can kind of research that, and starting in the 9th century, it was kind of incorporated into the English law system, and then later into the common law systems, and then after that, consequently, into the international law systems, specifically concerning human rights, as again, we initially stated that it was to deal with certain civil rights. Okay, so the role, as stated by Salmon, or Lord Salmon, way back when, he said that he understood that the amicus brief was to help the court and to expound on law impartially, and that's in the nutshell. So most of the time, these amicus briefs are done by advocacy groups. In relation to our court, specifically to the highest court of the land, the United States Supreme Court, it has special rules for the amicus briefs and the cases that are fileable for it. So Supreme Court Rule 37 states that the brief should cover only relevant matter that's not being dealt with by the parties that are involved in the issue, which can offer considerable help. And the cover must be made to identify the brief that the party is supporting, and if the brief supports affirmance or reversal. So those are two key rules for the Supreme Court. The court also requires that all non-government amici identify those providing monetary, or paying for it, preparation for the submission of the brief, and that the briefs must be prepared in booklet format, and there must be 40 copies must be served with the court. So those are unique rules with the United States Supreme Court. Now let's actually get into how to write an amicus brief for the Supreme Court. And there's a guide that you can actually download and you can check out. So who can file an amicus brief? The answer is anyone. Any entity can file an amicus brief. However, the counsel of record must be a member of the Supreme Court bar. So I'm going to say that again. Anyone can file an amicus brief, any entity, but the counsel of record must be a member of the Supreme Court bar. So the first thing that we talked about before is the consent to file or to leave to file an amicus brief must be provided by whoever's filing it, all the parties, by the court, and it can only arrive in a couple ways: by correspondence, by the parties that are presenting the amicus brief, which are included in the court's filing package. And you can request consent from all parties as soon as possible. The amicus brief must be filed at the petition stage, and you must submit your request for consent at least 10 days prior to your deadline. A blanket consent that some or all parties should be in your docket, and a motion for leave to file an amicus brief, which is granted by the court. And this motion is placed prior to the amicus brief and filed concurrently, that means together, and must specify how and when you requested the consents from all the parties and what their response was, if any. And you cannot file a motion separately from the amicus brief. They are bound together. The next thing would be the cover information. So there's the docket number, and that's the docket number of the court if it's joined multiple cases. The party names, they must appear on the docket. You must state whether the case is on petition, that means at the petition stage, or on writ at the merit stage. The lower court, as it appears on the docket. The name of your amici, or the person with party interest, the party that you're supporting, either affirmation or reversal, and then the address blocks, selecting one of counsel of record. After you've named your amici, you have to determine whether you are an amicus curiae or amici curiae. All right. So an amicus curiae is when the filing party is a singular individual or a single organization with an official or a legal name. The amici curiae is when there is more than one filing party and when there are groups of filers who are filing under a common banner, but where that grouping is not an official. So examples would be Mary Smith, amicus brief; General Motors, amicus brief; Boy Scouts of America, amicus brief. And then if there's multiple people like Tom and Jane Jackson, amicus brief, or the I guess you'd say the Atlantic Coast Conference professors, then that would be amicis brief because it's a bunch of people. For the amici filers, it's recommended that it be a title that can be remembered. So you would use something that's substantive. And all right, the next thing you would know is that the party supported. So you have to know which your party you're supporting. And with the obvious choices being in support of petitioner, in support of respondent, or in support of neither party, because you might have a controlling interest that the reason that you're actually filing this amicus brief. And there's some cases when there's like mixed parties, which is really rare. That's very rare. Okay, now here's the key part of the amicus brief is that, as it's stated in the rules, the curiae should bring to the attention of the court relevant matter not already brought to its attention by either party that's going to add considerable help to the court. So I'm going to say that again. It must be relevant matter that has not been brought to the attention of the court by either party that is going to be a considerable aid to the court in rendering its decision. An amicus brief or curiae brief that does not serve this court burdens the court and its filing is not favored. So the best briefs provide a unique point of view based on the experience of that amici, the person that's actually supplying or petitioning the court or submitting the brief. And those are going to be received with much more favorable consequences than those that are just random, inconsequential things. All right, so there's only two requirements on the contents of the amicus brief. Requirement number one, the first section must state the interest of the amicus party. Requirement two, the first page must contain a footnote that states whether the counsel for a party authored the brief in whole or in part, or whether such counsel or party made a monetary contribution intended to fund the preparation or submission of the brief. And it has to identify every person other than the amicus curiae, its members of council, and who made the monetary contribution. Requirement number three, if you do not have the consents, which means you don't have consent to submit this brief, you haven't spoke to either party, right, to file, you must file a motion to leave that precedes, leave to file that precedes the amicus. So it means that basically means that, okay, I haven't spoke to either party, but I'm filing this motion and now I'm going to ask permission. So judge, the court, please don't discard my motion. I'm going to go back and then speak to either party to get consent. And so this motion must state A, the timing by means which you sought the consent and originally, the party's response, or if they didn't respond, and the qualifications or the interest of the amicus brief. Okay, so that's your typical outline. There's the motion for leave the file, if necessary, the table of contents. There are the table of authorities, the interest of the amicus brief, the amicus brief itself with the argument 1, 2, or 3, the conclusion, and then your closing signature block, which is clearly identifying the counsel of record. And then if it has some appendix, some other little consequential notes that the word count for your amicus brief begins immediately after your table of authorities and runs all the way through, but does not include your signature block. And you must check that. Also counts footnotes. The word count for an amicus brief at the petition stage is 6,000 words. The word count for the amicus brief at the petition stage in the beginning is 6,000 words. The word count for the amicus brief at the merit stage is 8,000 words. The word count for the amicus brief at the merit stage is 8,000 words. And the motion to leave to file, is 15,000 words. The motion to leave to file is 15,000 words. Then you get to some deadlines. So the Supreme Court does not calculate the deadlines nor warrant the accuracy of the information pertaining to deadlines. It is the client. I will say that again. It is the client's sole responsibility to manage and meet the deadline. All right. So those are some interesting things. And then, get into the Supreme Court dockets, deadlines. So those are interesting things. And now I'm going to get into a case. And in the beginning, we talked about how most of the times that amicus briefs, not all the time, but most times, they're filed doing human rights or some civil rights, or someone that has a vested interest in a decision going a certain way, whether that's for an affirmation or whether that's for a reversal. I didn't actually think to bring this up because it would probably be hard to really discuss it at length. Like the NRA. The NRA files amicus briefs on behalf of gun rights and the Second Amendment. You will find them always involved in that area. There are certain lobbyists that and organizations that they represent. Excuse me, I have the belch. And so you will find them or people that are connected to them, or I can't say PACs, political action committees, but people connected to political action committees simply because they have vested interest in some laws or rules or administrative law or regulations that are going to affect them, their businesses or their livelihood, or financially or structurally. So you'll find situations like that. So every year, the Supreme Court selects about 80 cases from around 7,000, 8,000 petitions that seek to review. And that doesn't seem like an awful lot, but I don't really understand the entire Supreme Court docket. And from my understanding, the Supreme Court is very busy. So the court agreed to consider two cases that were originally filed in California that, depending how the court rules, impact the operations of charitable nonprofits. This organization, the National Council of Nonprofits, filed an amicus brief, as you see at the bottom of the screen again, amicus brief meaning the friend of the court or the legal brief, to alert the court to potential significant harm on the work of charitable nonprofits and thereby, according to the direct words, injury to the public. They warn, quote, that there is much more at stake excuse me, than meets the eye, end quote. And now let's get into a little background. So federal law requires that charitable or nonprofits to file with the IRS a Form 990, which is an informational return, including the Schedule B. And that records confidential or public or non-public basis the names and amounts given to the nonprofits, which they consider called to be significant contributors, quote unquote. So anybody that donates more than $5,000 or more than 2% of the revenue that is produced over the year falls into that group. Several states, including California, require that there is a file copy of 990 and Schedule B on a confidential, non-public basis when filing their charitable solicitation registration forms. So two organizations, vested interest, right? Americans for Property Foundation, or AFPF, and the Thomas More Law Center refused their Schedule B with the California AG, Attorney General's Office. So the California AG Attorney General's Office is charged with the oversight of charitable organizations, right, to protect the public from fraud and misuse and all of that. So instead, they filed separate lawsuits to stop any enforcement against them, so the AG could not look into the matter. Both of them claimed, that the First Amendment, freedom of association, allowed them to be shielded, basically that you cannot see their revenue, their tax forms, and that it would shield the identity of major donors. Now, if you haven't followed politics, you can understand how this plays. All right, so people can donate to people, but we don't want you to know how much they donate, and we don't want you to know who it is that's donating. We want to keep that a secret so we can constantly receive the donations, and we don't even have to report it. So you can see why this would be a problem. All right, so the district attorney, the California AG, basically barred the California AG from enforcing the law. Okay, Ninth Circuit Court of Appeals vacated those injunctions and sent those cases back to trial. The lower court conducted the trial originally, so the court of original jurisdiction, and they ruled for the AFPF and the Law Center that the filing requirement was unconstitutional. Like, you can't force us to do it, and it applied to them. The appeal on the Ninth Circuit Court of Appeals noted that the judge made, quote unquote, several questionable evidentiary rulings and reversed the decision for several rulings, including he applied the wrong legal standard. Fast forward to the Supreme Court. The Supreme Court then consolidates both cases, right? Even though the AFP's brief and the Law Center's brief raised arguments with some nuanced differences, both contend that the Ninth Circuit applied a legal standard that was a little more diminutive than it should have. Moreover, both entities were thinking that the AG may leak the information, it gets crazy, about the donors, and might harass their donors if they knew who they were. So again, it's like shielding people from discovery. So I don't want you to know who gave it to me, and I also don't want you to know how much they gave it to me. I also don't want you to know who the frequency of the amount that they've given it to me. That's my business, not your business, and that's pretty much the argument that's going on here in the nutcase. So they expressed concern that the major donors knew that their identities were being disclosed and confidentially just to law enforcement, so they would stop donating. You see what I'm saying? So if people know that what we're doing, we can't donate to you. So maybe there's something going on in the background. Maybe there's not. I don't know. We'll see. So the California AG brief urges the court to affirm the decision of the Ninth Circuit in this sphere. And the AG explains how the Ninth Circuit, not the trial court, applied the proper legal standard of exacting scrutiny to the state's confidential, non-public reporting requirements. And that is a mouthful. All right. So the AG basically said that the law and the facts support the Ninth Circuit's decision. And, on the face of it all, the challenges to the APF and the Law Center to the Schedule B requirement. So finally, the AG demonstrates that the evidence at trial doesn't support either group, the AFPF or the moral law, and demands that they be exempted from the Schedule B requirement. So on the surface, I guess it looks like it's a dry legal issue about what standard, and I'm going to read this exactly because it's complicated for me, what legal scrutiny a court should apply. Should it apply the Ninth Circuit's decision to the case, or should it apply the trial court's decisions to the case? And this is the case. This is the decision that's before the United States Supreme Court, the highest court in the land. So a large percentage of the 80 Amicus Curiae briefs were filed, right? And a large percentage of them are filed by entities that have been active basically over a period of time in election or campaign finance law. Now you can understand how non-charitable organizations and everything that's going on here regarding whether the identity of the donors to partisan political campaigns can be withheld to protect their anonymity, or should they be disclosed so that the voters would know about the dark money. All right, so in this situation, excuse me, I have to belch again. There were many briefs filed. All right, you can only imagine. So this is directly affecting political contributions, quote unquote. The briefs that support the AFPH and the law include several other think tanks, and they filed amicus briefs routinely, and these are briefs for conservative and libertarian interpretations of the law, and so forth and so on. And the Nonprofit Alliance Foundation joined the Association of Fundraising Professionals and the Arizona Attorney General, joined by 21 other state attorney generals. And the arguments of the facts supported that the California AG were included in all 12 Scholars of the Law nonprofit organizations and just more. So the court scheduled oral argument for Monday, April 26th, and it granted the motion by the United States Solicitor General, who had also filed a brief, to participate in the oral argument. So why do we file these National Council of Nonprofits amicus briefs? The traditional role basically is that amicus brief is to draw the court's attention, something that it should not or could not or would not know when it's writing its opinion, right? Because it has to be a relevant matter that the court could not have known or would not have known, which would aid the court in rendering its opinion. For instance, in a case with radio broadcasting, right, the television industry might urge the court to make a ruling that includes television broadcasters because the same principle should apply, or warn the court that writing so broadly would mess up the television because the two industries are different. Excuse me, I spoke a little fast there. All right, so let's get to the real issue. Their brief, they're speaking the national, right, is atypical because the parties that filed the lawsuits are not representative of typical charitable nonprofits. So 97% of charitable nonprofits spend $5 million or less annually. 92% spend less than $1 million. The charitable profits may not engage in partisan political activities or against any candidate for a public office. By contrast, the American Prosperity Foundation would spend $18 million in 2008, and also is related to some of the officers and board members of Americans for Prosperity, which is AFP. They're also politically active under 501c. So on. The point to the court is that you should not make changes to the law affecting 1.3 million charitable nonprofits based on the actions and wants of larger outliers, meaning people that can do this. They're larger, and then there's a bunch of small people that this is going to affect that don't necessarily receive the funds that these larger groups are receiving. And so you don't just change the law simply because it's affecting a few. Think on the larger picture that there's a lot of people that are going to be affected by this and that are not in the same circumstance, but will be in the circumstance if you change the law. All right, so context is basically this. They warned the court, and I'm going to say this clearly and quote it, this is a campaign finance case that is cloaked in charity law clothing. And if you mix the two, you're going to create significant problems, and which I just explained briefly. So their point to the court, again, is the court should recognize, and I'm going to read it exactly, that the case before it is thinly veiled election law case. And that's what I said from the beginning without giving it all away, is that it was about election law. And so the court is don't use this to strip away the public trust, and their reasoning is sound. And that's pretty much the nutshell of the case. What the court's decided, I'm going to let you figure it out. But this is the reason why amicus briefs are filed. Okay. That's all I got. And I hope that you enjoyed my spiel. And I'm out of here on the amicus brief. And good luck, everybody. Bye.